Okay. So everyone, if you require English, please select English. If you require Spanish, please select Spanish. I'll put those instructions as well in the chat. Go ahead, Nipa. We're ready.
Okay, great. So I'm going to share my screen. Let me do screen share. And if you can let me know if everybody can see it.
We're good.
Okay, great. All right. So just to let everyone know, I will be taking questions at the end. So a lot of your questions may be answered throughout the duration of the presentation. So that's why I want to take questions at the end. You can just put your questions. I believe you're able to put your questions in the chat if throughout the presentation, just in case you forget. If you're not able to put it in the chat, just hold it for at that towards the end. But yeah, you could put it in the chat as I'm going through the presentation, and then afterwards I can just like go through it. Yeah. So I work for Housing Court Answers, and I'm going to discuss a little bit about what we are before we jump into the presentation. So what is Housing Court Answers? So we are a nonprofit organization that provides housing related information. What we can do is we can help screen seniors and homebound tenants for attorneys. This is a very limited service right now, to be clear, just because in housing court, the free legal services, there is not enough attorneys at the moment. So it's very few people that are unfortunately getting attorneys. So right now we're only screening seniors and people with disabilities that make them homebound for attorneys. We ourselves are not attorneys. So just to be clear, like our organization itself does not have attorneys. So we cannot, take on the cases or anything ourselves. Um, we help tenants access rent arrears assistance. So if you know anybody who has back rent owed and they don't know where to reach out, you can give us a call and we can provide a referral based on a screening we do. We ourselves do not have any money. We are not a rent arrears assistant agency. But yeah, if you know someone or you're struggling with back rent, even if you're not in court, feel free to call us and I will post our number on the chat towards the end of the training. We help unrepresented tenants and homeowners navigate housing court procedures. So just discussing the court process, we are one of the few agencies that can help both tenants and homeowners, but we only help small landlords who don't have attorneys. And that goes for every one of our clientele we can help. If you have an attorney already, we only help unrepresented persons. So we cannot assist people who already have attorneys, unless you're calling for like background assistance or something. That is fine, but we cannot discuss your case. You should refer to your lawyer. The lawyers are the experts in the law. So in that case, we defer to you to your lawyer. We can explain how you can get repairs if you're having repair issues. And one of the things that we are able to do in the courthouses itself, or even if like sometimes you're not, you call us over the phone, depending on the form you need, we can help you explain how to fill out basic court forms. So it's not all court forms, it's very basic ones. Again, we're not attorneys, so some court forms may require some, legal training, things like that. We would not be able to assist with those, but basic court forms, how to file a case, in order to show cause generally, things like that, we can help you, fill out. We have tables in 4 of the 5 boroughs. So unfortunately, we don't have anyone in Staten Island, but you can always just call us and we're there at the tables Monday through Thursday, 9 to 5. We're not in the courthouses on Fridays, but you can always call us. We are open Monday through Friday on our hotline. And anybody that's interested and wants to write it down, it is 212-962-4795. So just 2 online systems you may want to reference for if you have a court case. So what is NICEF? NICEF is the link for the website. So NICEF is an online electronic filing system. And basically what it is that if you're an attorney or if you know how to utilize the system, you can file a case online. And as long as it's electronically filed, people can see all the court documents generally online. So if you lost your court document or something and it has been filed electronically, you're able to look it up online. All the documents, things like that. eCourts is the court's online calendar system. So the thing is with eCourts is it's basically only for you to see when is your court date. So if you don't have a court date, it won't show up in the it will say case not found, but that doesn't mean you don't have a case. It just means you don't have a follow-up court date. It could be in a different process or something. So if you get court papers and you run the index number, which is how we usually search for cases, and it says case not found, that does not mean there's not an ongoing case. So do not ignore court papers ever. But yeah, it just means that if you need to check if you have an upcoming court hearing date, you can use eCourse to check it. Now, housing court, during the pandemic was making accommodations to appear virtually to answer over the phone, but that was only because of the shutdowns. That is no longer a possibility. The only time it is possible is if you have a disability. So you would need to call in advance to get that accommodation. So the number is 646-386-5409. And I want to be clear with the accommodation. It's not that everybody gets to attend virtually meaning over the phone or, via, video call in. There's different types of accommodations. So if you think of someone who is legally blind, it's not that they can't come in, they may not they may need a different type of accommodation. So it's not just for people who can't appear because they're homebound or something due to being bedbound. It's also for people who have other types of disabilities too and need a different type of accommodation. So any type of accommodation you need when you're in court, you call this number in advance to request that accommodation. So yeah, so everybody in housing court they are able to be screened to see if they can get a free lawyer to represent them. Just to be clear, the free lawyer services are for people who are earning below the 200% federal poverty level. Um, so you have to be at or below 200% of the federal poverty level. And this is for housing court in New York City. So during the duration of this presentation, it's for people who live in New York City. Outside of New York City, we have different mayors, things like that, different laws, rules. So I don't want people to take what we learn here and apply it to if you live elsewhere or if you know someone who lives elsewhere, you know, don't give that information because their rules and laws are different than ours, and we do not deal with those counties. So I don't want to give out incorrect information. But yeah, the free lawyer services is for people in New York City who are in housing court and earn 200% of the federal poverty level or below. And then tenants who are 62 years or old or over. Now, just because you're eligible doesn't necessarily mean that you will get a lawyer at this moment, simply because there unfortunately are too many cases. Part of that is the backlog from the pandemic when the courts were shut down. Um, and then also there's new cases being filed. So there's not enough attorneys for all the cases going on. So even if, let's say, you're within the criteria, if different providers are doing the free legal services, so Legal Aid Society, LSNYC, BKA, but all of them don't have enough attorneys for all the cases going on at the moment. So even if you're eligible, if they don't have a lawyer and then within their office to take on your case, you will have to fight the case on your own. And the case will move forward. If you want to like argue that it shouldn't, you could feel free to do so, but just know that cases are moving forward even if you don't get a lawyer. And then if you're not 62 or older, but you have a disability, you can ask the judge to refer them for free legal representation. So the judge can make a legal request from one of the providers to refer you to be screened. So the judge will say, okay, I'm giving an order for you to be screened for a lawyer, but that doesn't necessarily, again, even if they do the screening and you're found eligible, just because you're found eligible doesn't mean you will get a lawyer simply because there's not enough attorneys. So this training, what we're going to be focusing on is holdovers. So to begin with, what is a holdover? So a holdover is a type of case in which the landlord wants you out of the apartment for whatever reason. Just because you pay the rent, like, doesn't mean that you're going to be able to stay. So there's two types of cases in housing court. One is non-payment, and that's really about the rent. So as long as you pay the back rent that you owe, that means you get to stay in the apartment by a deadline. Holdover is the opposite, in which that you may owe the rent and the landlord may still want the rent, but just because you pay the rent doesn't necessarily mean that you're going to be able to continue staying. So some of the things we're going to talk about is what are possible reasons and defenses you may have, if the landlord wants you out, why the landlord wants you out, how does the case start, what will happen on your court date, what happens after court. Again, just reminding everyone, I'm not a lawyer. We talk to people about the court process, but I cannot give you legal advice. So if, again, try to get a lawyer to get some legal advice. We have our hotline. If you need legal advice and you're not able to get a lawyer, you can call us and we can transfer you to get one-time legal advice. But yeah, we ourselves are not lawyers. So basically, a holdover is a type of eviction case brought by the landlord for something other than the rent. The term holdover refers to the fact that the tenant is staying beyond the time when they had permission to be in the apartment. So they are holding over past their lease or permission time. So you may have a lease and you signed the lease 2 years ago and then you never signed the lease again. You're now and the lease had expired like in 2023. You're now something called a month-to-month tenant. So you're staying there with permission past when the lease expired, but now the landlord may just want you out. So you're holding over. But depends on the type of household that you live in. So landlords of regulated housing need a good cause. So they need a reason to want you out. So even if there is a lease or there isn't a lease, they may need a good reason if it's a regulated type of apartment. And we'll go into that a little bit more. Now, unregulated landlords or households that are unregulated, they can evict without a good reason once the lease expires. And when I say the households, I don't mean the type like how many people in the household or things like that, or the type if there's children. I mean, if it's a NYCHA building, if it's a rent stabilized apartment, if it's a 1 to 3 family private home, those are what's going to affect whether it's like a regulated or unregulated. And we'll go into that a little bit more. So recently in April of 2024, there was a great bill that was passed. It's called the Good Cause Eviction. So essentially the Good Cause law means that unregulated apartments that previously did not need a reason to want you out, like they could just say, I want you out, and I don't need to provide a reason. Now, some of those unregulated apartments will actually need a reason. There's also something called the no grounds. So no grounds, means that they don't need a reason. But with the good cause law, they will need a reason in particular types of buildings. We have a more extensive training about this on our YouTube website, and I will post that on the chat so everybody can go check out the more extensive version. I'm going to talk over it like briefly. So landlords who own regulated housing or buildings covered by the good cause eviction law need a good cause or grounds. So what are good reasons for a landlord may want, or may use in order to say, I need you to leave, because these are reasons, valid reasons to for me to want you to leave. So things like violating your lease. So some, apartments, you install a washing machine and people don't realize it. That can be a violation of a lease because you may need to have gotten permission, or if you're subletting the apartment without permission, or things like that. If you're causing a nuisance, nuisance is basically behavior that is self-harming or harm to others. So if you have a dog that bites, or if you're hoarding, a lot of people may not think of hoarding as nuisance behavior, but hoarding is actually dangerous to yourself and others, simply because it creates a you may be obstructing like fire exits or things like that, or like a quick exit in case of a fire. And sometimes hoarding can lead to like certain types of like, infestations. So hoarding can actually be considered a nuisance. Uh, if you're doing something illegal in the apartment, like unfortunately selling drugs, if you're violating the regulations. So certain types of, if you live in a type of apartment like a NYCHA, they have specific rules there. So you cannot have someone who's not on your NYCHA lease live with you. You know, that is a type of violation of of the regulations you accepted when you move into NYCHA. So that is one example. Or if the landlord wants to demolish the building or use it for a different purpose, so like not, use it as a commercial setting, things like that. So those are good causes to want somebody out. Now, a landlord who owns an unregulated house and are not covered by the good cause eviction, they can start an eviction case against a tenant for any reason. They can start the case when the lease expires. And if there's no lease at the end of the rent payment period, so let's say you pay, your rent on a month-to-month basis. Once the month ends, then they could start the process to want you out. The landlord must serve a predicate warning notice first, telling the tenant the tenancy is terminated and they have to move out. So in a holdover, if it's an unregulated apartment, well, you need this regardless. Like the thing is, the courts require everybody to get a chance to deal with the issue before it has to be addressed at a court level. So there's a certain type of notice that needs to be sent before you're taken to court. The courts, want you to be given a chance to resolve the issue outside of court first. So when we talk about rent regulated or apartments that are covered by the good cause eviction, these are some differences. So anything that is rent regulated or subsidized housing, they're not covered by the good cause eviction law because they have their own protections. So in a rent stabilized apartment, you have a right to a lease renewal. So it would be it wouldn't be covered by good cause eviction now because it's already has those protections built in. NYCHA, Section 8, Mitchell-Lama, project-based Section 8, supportive housing, apartments that have a tax credit, there may be protections built in where they have to renew your lease. Unless there's a good reason to not renew the lease. So those aren't covered by good cause evictions. Now, what is covered by good cause evictions? So the thing is, the best way to understand what is covered by good cause eviction is by understanding what's not covered by good cause eviction. So if you look at this, right, buildings built after 2009 are not well, they have to be covered. Buildings built after 2009 are not covered. They're covered by good cause eviction. So anything before 2009, they would not be. A market rate or a deregulated building with 10 or more units. So if it's an apartment that has like 8 units, it would not be covered. Tenant is violating the lease and is not paying the rent. The unit is in a smaller building, but the landlord owns more than 10 units total. So this is the part of the law that's a little tricky and gets people confused. So if you're a landlord, let's say your landlord owns one building that has 6 units, but then the landlord also owns a building, another building in another area that has 4 units. So that would be 6 plus 4. That means 10. So now you are covered under good cause eviction. Because in total, your landlord actually owns 10 units, even if they're in different places. The trick though is like, and this is why you would want to watch the video, and I think this is something that's still going to be regulated in courts and stuff. A lot of times landlord register under different LLCs, things like that. So your LLC, the apartment that you live in, your LLC may be, I don't know, Promisa. And then your landlord owns the same building, the same, your same landlord, the person that you have contact with, may own another building in another area under, LLC Synergia. So now are they covered under 10 units total? So that is something you would want to check out our good cause eviction training about, because it does discuss this. And it's not a straightforward answer. It's a little bit tricky. So I don't want to get too detailed into it. But also the law is very fresh and it's very new. It just got passed in April. So things may be debated in the court system, and things may, the understanding of how we have it right now may change as it's, debated in court. So yeah, we'll see. If the apartment is a co-op condo, then it is not covered by good cause eviction. It doesn't matter if you're renting directly from the shareholder or from the management itself or the board. It's a co-op or a condo. If it's owned by a nonprofit, so like supportive housing apartments, they tend to be owned by a nonprofit, then it's not covered by good cause eviction. And the unit rent has to be less than 245% of the FMR. So there are it has to be within a certain income limit. So your rent itself. So if somebody is like on a 1-bedroom and their rent is like $10,000, then no. But if it's below the 245% of the FMR, then yes. I don't have the exact numbers for that, but you can Google it and there should be. And FMR refers to fair market rate. So yeah, so that was just basically about like unregulated by regulated. But the reason we discussed that is, again, depending on the type of apartment you live in, you'll have different defenses. So in a holdover case, we talked about they need to serve you something called a predicate notice, and that notice must be served before the start of the case. That notice may seem very threatening and it may seem like, oh, you have to leave. No, the language they use, it's is going to be like very formal and it may seem threatening, but you don't actually have to leave. In New York City, a landlord cannot evict you without going through the court system and a marshal's notice being issued. And the marshal's notice is issued by a judge. So if somebody just gives you the notice and at the end of that notice period, they decide to change the locks or something, that is called an illegal lockout. And the fastest way to get back into the apartment is don't argue, don't get into a fight with your landlord. Just call the police right then and there and let them know you've been illegally locked out. You need to be near the apartment. And you know, and they should assist you. Sometimes they don't, or they may say you need to go to court. Then you would go to housing court and file an illegal lockout case. But the predicate notice has to come at least a month before the start of the case. If the landlord has cause or basically a reason, the notice will state the reason. It might give you a time to cure or fix the problem. So sometimes the landlord, and depending on the type of apartment, specifically also rent stabilized apartments, they may say, we've been noticing this issue and you have this amount of time. It may be like 10 days or 30 days, depending on the reason, to fix this issue, or we're going to start the case. So an example of a washing machine, if you installed a washing machine without permission, the landlord may say, okay, well, you need to remove the washing machine, or we are going to, that is a reason you didn't get our permission. And again, like it may seem like, okay, why do I need permission? But depending on your lease, you may need permission. Because at the end of the day, it is a rental. It's not, unfortunately, our own apartments that so it is a rental. But yeah, they will give you that type of notice. And that, remember, that's not just for every type of apartment. Some apartments, they don't need to give you time to fix the problem. Some regulated apartments, they do. So they'll give you that, and then if you don't fix the problem, they'll send you a notice stating that, like, hey, okay, well, we're terminating your tenancy. So depending on how long you lived in the apartment, you'll get a certain number of days before a court case can be started. So if you lived in the apartment for up to a year, then they only need to give you 30 days to move out until they can start the court case. If it's more than a year, less than 2, then 60 days. More than 2 years in the apartment, then 90 days. So that's what the notice they give you before they start the court case that has to say. So you have this many days to leave, or we're gonna start the court case. And I'll send you, and so this is actually an example of a notice of termination of monthly tenancy. So if you see here, it says, the landlord of the above premises elects to terminate your tenancy. Unless you remove from said premises, the day on which your term expires, the owner will commence summary proceedings under the statute to remove you from said premises. So yeah, if you're not familiar with the language, then absolutely, like you may think, oh, okay, I have to leave. They're threatening to evict me. This is the marshal's notice, but no, this is not a court notice. This is a notice they need to send before they can start a court case. Because this doesn't have, and then we'll discuss, because there are certain things that a court notice has that this notice won't. So when they actually file the case, once this period, so in this case, the March 31st deadline, they have to wait till the March 31st deadline. They can't do it before March. But once the March 31st deadline has passed, then they go into court and actually file the case. And that is called the notice of petition. The notice of petition will tell you when to come to court and where to go. The petition itself tells the tenants the reasons or the grounds for the holdover, and it states who the landlord is, who the tenant is, if there's any subtenants. So this is actually what the notice of holdover petition looks like, and there's other parts to it. So before I was saying that there's difference between the predicate notice, that's the pre-court papers, and the notice of petition. So if we look here, The predicate notice does not say Civil Court of the New York City County of Bronx if you go on top. So I'll bring it back. This is just, it says it filed Bronx, but this is because we pulled off online. But the actual notice itself, it doesn't say that up here. Another way to decipher is if this is the actual court papers, is that the predicate notices will not have a judge's signature on it. If you look on the bottom of a predicate notice, it will say, it won't say it don't have a judge's signature. It'll just have like maybe the landlord or the landlord's attorney's signature. So this is crossed out, but blanked out, but you'll see right here, like it'll just say the name of the attorney. And then here it'll say an index or LNT number. So generally with this, it's blacked out for privacy reasons, but it'll say an LNT number. LNT number indicates that it's a court case. A court case has been started. LNT stands for landlord and tenant court. Different types of court have different like index numbers. So if it may say index number CV, that's civil court, but when it says LNT, that means it's in housing court. So you need to look for an index number or LNT number, and that means that there's a court case that has begun. And also it'll say right here, notice of holdover petition. That means you have a court case that has been filed against you. The court case has been started, and now everything you do needs to be addressed at a court level. Some people will say, you know, oh, I spoke to my landlord. No, you have a court case. Your landlord's interest is not to help you right now. You need to deal with even if you're speaking to your landlord on the side, you need to deal with everything at a court level at this point because the case has already been filed. And if you don't, you could get a default judgment, which means you are put at risk of eviction. So right here, when you get a holdover petition, unlike a non-payment case, a holdover petition comes with a court date already. So it'll tell you have to come to the court on this day, blah, blah, blah. And then again, some people will say, well, I spoke to my landlord and we made an agreement. After they get the notice, it doesn't matter. They could tell you one thing on the phone and do something else in court. So make sure you don't miss any court dates. Make sure you don't ignore court papers. Yeah, but the petition will also say who's suing you and, you know, who is being sued in this apartment. I just want to say John and Jane Doe. For a lot of people, they're like, who's John and Jane Doe? John and Jane Doe refers to anybody who lives in the apartment and the landlord may not know their name. Basically, it's to evict everybody in the apartment. Because they only name one person, maybe like Jasmine Smith is the person, but she has like roommates. Well, you know, if it's the case is only against Jasmine Smith, there's a possibility that if an eviction will occur, it'll only be against Jasmine Smith because they didn't name anybody else in the case. So they put John and Jane Doe essentially to protect themselves. Now, when court papers are served, there is a legal process to how they must serve the papers. If they don't follow this legal process, then you can use that as a defense in court and potentially get the case thrown out because they didn't you know, follow the legal process of how you're supposed to. So basically, what is the service of court papers? It just means that when you're taken to court, you have to be notified by your landlord that, hey, I took you to court. So the requirements is that they first have to do a personal delivery. And when they're serving the court papers, this cannot be your landlord itself. It can be, and we're talking about the petition specifically, in this case, it cannot be your landlord itself. It's a volatile situation. The courts don't want, you know, fights breaking out or anything. It has to be a third party who has no vested interest in the case. Frequently, it will be a process server. So a process server is someone who does this professionally. It could be a neighbor or, you know, a friend, depending, on the type of, if it's usually a lot of times like small homeowners may use a neighbor or friend, but it has to be a third party who has no interest in the case. If your landlord who lives in the apartment, in the same building as you and his family also lives in the apartment, it can't be them, things like that. So if they're not served correctly, you can actually dispute the serving process in court, and cases have been thrown out because there wasn't proper service. So first they have to make 2 attempts within, it's not on Sundays, or it shouldn't be on someone's religious holiday. Different religions have different, religious holidays. So that should tend to be avoided, and it has to be between 6 a.m. and 2 p.m. So they have to attempt to come and give you the paperwork to yourself twice in person. The rule is not they have to be successful, they have to make the attempt. And then if they on the second time, if they can't reach you personally by knocking on your door, you may see frequently that there's a notice left on your door or underneath your door. Don't ignore that. They have left the court papers. Now, once they are not able to get you personally, then they also will have to then mail it out. So they have to mail it out twice, one via certified mail and one via regular mail. Substitute delivery, I just want to be clear, is that, let's say I'm Jasmine Smith and my landlord took me to court. Now I have my friend, I don't know, dog sitting that day, so they're in the household, but I'm not home. That means that they handed the apartment to my friend. The person serving the paperwork doesn't need to verify that the person actually lives there. Um, it just means that whoever they can find, they can give it to that person, even if they don't live there. It has to be of suitable age and discretion. So if it's like a 10-year-old, that's answering the door and they take the paperwork, again, you yourself will have to make the argument, hey, my 10-year-old answered the door. That is not someone you can leave paperwork with. Because if they do find someone, but if like Jasmine Smith, like Jasmine Smith, answered the door and I gave my name to the person serving the paper, Jasmine Smith, that means I only get that one copy. But if it's someone who, let's say handed it to my friend who was babysitting that day, then they still have to mail it out. But yeah, it has to be someone of suitable age and discretion, or that could be a defense, like the 10-year-old. But again, if you have a 10-year-old answering the door, there might be other issues that come up. So yeah, you do need to be careful. Yeah. And if it sounds like, even if it's someone like who is an adult, but let's say, like a very, like someone who's clear, shows clear displays of like dementia or something, that is and discretion, that is not someone who's capable of, receiving these papers, but they answer the door. That is an argument you can make, like, hey, they have clear signs of dementia. Or they don't seem mentally fit. But you have to make that argument in court. And then there's a link here for the rules of service. Also, I just want to say, a lot of people, when they get certified mail, they will say, I did not go check my mail. I didn't check my mail until this date. Because when you get the court papers for a holdover, it has a court date, but they actually can't serve it to you more than 12 days in advance, but no less than 5. So if you're not someone who checks your mail frequently, but they actually did do their part, they mailed it out and by certified mail and regular mail, and you're the one who doesn't check your mail, that is not a defense. If you don't have access to your mail, like you don't have the keys, or your landlord interferes with your mail, that could be a defense. But if you yourself don't actually check your mail, that is on you. That is not a defense, because the person doing the service of the papers, they did their part. So now you go to your court date, you've gotten the paperwork. So now you go to your first court date. What will happen on your first court date? So your first court date will be in the resolution part. So basically, do not be late. Remember, like, you need to remember that you need to go through security when you're going through court. And, sometimes people just don't know where to go. So you need to give yourself time. So if your appointment is at 10, don't arrive at 10. You need to be there like 9:30. A lot of the courts are extremely busy. And in some courts, like Brooklyn Courthouse, the building that it's not just for housing court. There's also civil court process. So some of the courts have other, court types of court cases within that building. So that general line for security could be extremely busy. So you need to make sure you give yourself enough time, because if you don't get there on time and they call your name, and you've missed the court date. So now you may have to do something different, or you may have defaulted. So please don't be late. Um, if you have childcare, make sure you set up care for that day. Don't assume that, like, hey, a lot of people say, like, I dropped off my kid to school and then I came. Um, that that's like, I understand the reasoning, but at the same time, you need to like prepare in advance. Because you might, if you get stuck in traffic or something, and your case is at 10, that is risky. Um, so your first court date is the resolution part. What that means is that before you get in front of the judge, you and the landlord will sit down to see if you guys can come to an agreement. Everybody goes through this process. And the court attorney will be there. The court attorney is the judge's assistant, but that's before you get in front of the judge. On your first court date is your chance to get screened for the free lawyer. So we don't make the referrals anymore. We used to make the referrals during the lockdown period, but now we no longer make the referrals for the free lawyer. It's on the first court date. You do not walk away without being screened for a free lawyer. A lot of times, the organization that is doing the screening that day may say, okay, I'm going to get your name, I'm going to take your name and number, and then I'll give you a call back. If they say that, make sure you get their name or number, or at least the name of the organization they work for, because we don't know who you spoke to that day. There's different providers every single day. So if you call back, and a lot of times people don't get callbacks, and we don't know who you spoke to. So make sure you get the person's name or number, or the name of the organization they work for. And then you'll get a new date to call back. Now, in the Bronx, the first court date is virtual, so you don't have to go in person. You can if you want, but you don't have to go in person. And in the Bronx, the first court date is just for you to be screened for a free lawyer. In other courts, the first court date is for you to be screened for a free lawyer, but also you will sit down for mediation. But you can go to the judge and say, I would like an adjournment, which is a rescheduling of the court date, before I sit down for mediation, because I want to be screened for a free lawyer. Yeah. Or if you can't get a free lawyer, if you're not eligible, you can ask for an adjournment. Generally, you are entitled to at least one adjournment. Like, it's not going to be an issue. If the very first time you go into court and you want an adjournment, you're going to be granted 99% of the time, because it's the very first time. Yeah. So just make sure that you get the screening. You don't leave the courthouse without being screened for a free lawyer, or at least getting the contact information for the person doing the screening. Unfortunately, sometimes they're not there because of the lack of availability. Yeah, if that happens, just feel free to call us. If someone's asking you financial questions, then yeah. But also, whoever you speak to in court, just make sure you ask them, what is your role in the court? Because sometimes you're speaking to the landlord's attorney and you don't even know that you're speaking to the landlord's attorney. You may be giving away information that you don't want to give away. So ask them, what is your role in the court? Are you the free lawyers for tenants only? Are you the landlord's lawyer, or are you the court attorney? The court attorney is not your attorney. They are the judge's assistant. Their goal is to try and clear cases as quickly as possible. So getting you guys to an agreement. They have a different goal. The only person who has only your interest will be the free legal service providers. So just make sure whoever you speak to, it's your right to ask them, what is your role? Who are you, essentially? Now, on your court date, a couple of things can happen. So if you and the landlord come to an agreement, then the case is resolved with something called a stipulation. That is different than the case being closed. A stipulation may be, okay, we don't need to go to trial, basically. Instead of going through the trial and the judge issuing a decision, me and the landlord, we came to an agreement amongst ourselves. Now, the stipulation, it is a legal order, because the judge signs off on it. So regardless, whether you can't just say like, I didn't understand it. You're signing it. Both parties have to sign it. So make sure you understand if you sign a stipulation. Um, and yeah, you can negotiate during the stipulation. You can push back, things like that. You can write the stipulation. Um, or if you guys can't come to an agreement, you can go to trial. Trial doesn't take part the same day. You'll have to be scheduled for trial, or the case can be dismissed. So, let's say if you remember, you have to make the argument. Maybe the landlord hasn't done something right. So let's say, the service process that we talked about before, it was given to a 10-year-old, who, who can give it to a 10-year-old? They're not like, of a suitable age to really receive court papers. So if you argue that, it was given to them, it should have never been given to them, then it could potentially be dismissed by the judge. And then they have to restart, the landlord has to restart the process, or discontinued. Landlord drops the case, maybe because the tenant has paid. So sometimes, like, once the case is filed, some people will, you know, maybe the landlord really was just irritated about the rent not being paid, and they're actually okay with you living in the apartment. They just wanted their money really, or something, or maybe they changed their mind. They no longer want you out. They themselves, a landlord can discontinue the case at any point because they are the ones who are filing the case. So at any point, they themselves can discontinue or adjourned. Adjournment like means it's rescheduled to a later date. And either party can make that adjournment request, and it's up to the judge to approve it. Again, your first adjournment, you're most likely going to get it. So now we're going to talk about the stipulations. So remember, the stipulation is the agreement that you and the landlord came to in court. It's signed off by the judge. So remember, it does become a legal order and you are bound to it. Different types of housing, different types of cases will have different things in their stipulations. And some of the possibilities may be fixing a lease violation. So removing a dog. So if landlord is saying like, hey, I took you to court because you're violating the lease. Okay, I'm agreeing to kick out the person who's been subletting the apartment. Okay, so we're agreeing that you'll drop the case if I do this. Probationary period. So if a probationary period is essentially if there's a certain point in certain amount of time that you're going to be on probation. This may happen a lot with rent stabilized apartments, because remember, rent stabilized apartments, you have the right to a lease renewal. So they need a reason. So if you don't do something for a certain amount of time, then we will drop the case. Anybody who's agreeing to a probationary period, you should get legal advice. That is very risky. Probationary periods, just like in criminal sense, could mean a lot of things. So before you sign that, you try your best to get legal advice. If it's a household or unregulated where they don't need a reason, maybe there is an agreement to move out with a deadline. Does the rent have to be paid during that time? Landlords, even though you have to leave in a holdover, landlords are legally entitled to the rent. Only the landlord can waive the right to receive rent, because the thing is, you're still living in their property. So yes, they want you out. And for a lot of people, moving out costs money. So they're like, how am I supposed to pay the rent and move out? Unfortunately, legally, they're entitled to rent money essentially while you're still utilizing and living there. But the landlord sometimes may want you out so bad that, they're willing to say, okay, if you leave by a certain date, I'm going to waive the rent that's owed or any back rent. That's up to you guys. You guys have to negotiate that. And then there will be conditions in which the apartments will have to be left. So we're going to go over some stipulations right now. So the one thing, the stipulation, remember I said, you have to understand everything that you're signing in a stipulation. If you sign it and then come back and say, I didn't have an attorney, I didn't understand, that is not really a defense. The presumption is that whatever you're signing, you are understanding what you're signing to. So a lot of times people sign these agreements, but they don't really understand. So we're going to briefly go over some examples of a stipulation. So if you check the highlighted section, it says respondent to vacate premise in broom clean condition, free and clear of all occupants. What that means is when you leave the apartment, you have to make sure it is clean and all the property is, taken out and free and clear of all occupants. That means everybody who lives there, even if it's your roommate who's not on the lease, they can no longer be there. This is the agreement that you agreed to. Any property left in premises will be deemed abandoned and disposed of by landlord without liability. What that means that, let's say you left your mini fridge there when you're intending to come back, but you agreed that, hey, when I leave the apartment, my landlord can throw out that mini fridge and I can't sue them for it because that's what I'm agreeing to. Represents being sole occupant of premises. I am the only person in this apartment. I am saying that I'm the only person in this apartment and will not sublet, assign, permit any person to possess the apartment. So I am saying that after I sign this agreement, I'm not going to bring someone else in and I'm not going to give someone else the right to sublet the apartment. This is a little bit, this honestly, as someone who works in housing court answers, I would see a red flag because why are they saying a sublet? Do I have the right to sublet? Is this a rent stabilized apartment? Some people don't know they're in a rent stabilized apartment. So for me, I would want to check why that language is in there, but maybe they're just trying to protect themselves. But yeah. Upon default, warrant to execute by service of marshal's notice. So, you know, you look at number, there's like we're not going to go over it all, but there's different conditions that you're agreeing to. So you have to follow all of the conditions. Um, if you violate let's say you follow number 3, but not number 2, then you're in defaulting. So that means that once you don't follow this agreement, that means the marshal can come. The marshal still has to come and give you the notice, but that means you violated the agreement. So you have to follow all the parts of the agreement, not just one. This is another example of agreements. So the first highlighted is waive all defenses jurisdiction. That means you're agreeing that this is the proper court. You see the earliest eviction date is September 18th. But then this is something I would actually, number 3, where the highlighted, this is something that you can contest because it says the earliest eviction date is September 18th, but it says execution date through September 15th. That is confusing. You need to get clarity. Which is the date that you need to be out by, the 15th or the 18th? So you're signing agreement, but again, you want to get clarity on that. The next highlight, possession free of all persons and property. Respondent represents that no other adult resides in premises. Some people make agreements while they're afraid and they say nobody else lives here. You just said nobody else lives here. That if somebody else lives there and when you leave the apartment, somebody else is still living there, you're in violation of the agreement. The parties reserve their claims and defenses as to arrears and future use and occupancy. So basically, they're saying that both sides, you didn't discuss whether they're gonna waive the rent or not, or if the rent has to be paid. They're reserving the defense and their claim. So basically, when you leave, sometimes what can happen is that the landlord takes you to court in a different regular civil court. In this case, they're saying we're not going to discuss this in this court. We're just going to hold off on that until for a different court. They could come after you or they could choose not to. It's up to them, honestly. And then you would have to make the defense in another court. Petitioner to provide data receipt for keys. This is super important, and I like that was included in there because when you turn over the keys, as long as empty, you turn over possession. But sometimes, you want to get a receipt that, hey, I turned over the keys this day, because then what if the landlord wants to come back and say, you didn't actually move out that day? Nope, I have the receipt and you signed off on it. So I like that. And I like that it's clearly, it should be done anyway, but I like that it's a part of the legal order. Another example, this is a printed out one. So warrants to issue forthwith execution stay through and include February 1st, 24, final vacate date. Respondent shall vacate and surrender the premises on or before the vacate date in good and broom clean condition and free from damage, debris, occupants, pets, and possessions. This is a final date. No default shall be de minimis. The surrender of the premises shall be done by respondent returning all keys to the premises, including the building key and mailbox keys to the petitioner, who shall conduct a walkthrough and provide a dated receipt. Anything remaining in the premises shall be deemed abandoned and discarded without liability. And if we go down to the bottom, it says security deposits are, if any, are forfeited. So they're clearly, this is a very clear one that you're going to leave by the first, but also they're in the agreement, which is, this is actually a good thing that you're going to return the keys, and then the landlord themselves are going to conduct a walkthrough and provide a dated receipt. You should do a walkthrough with your landlord, because if they want to claim damages, then you should afterwards, and you say no, there was no damages. Well, it's best to do it together, because then you may get an opportunity to fix that damage. You should also take pictures and things like that. But sometimes landlords, what they will say is that, "Oh, okay, well, I don't have time." But you just had a agreement where they said they'll do a walkthrough. On the walkthrough will provide a dated receipt. What I would have liked better is that it says that we'll do the walkthrough together, because it just says that the landlord will do a walkthrough, but doesn't say together that I will be present for the walkthrough. You have the right to be present, but if it's said that, like, let's say the landlord, you're moving out and you need the walkthrough, and this particular document says we need to do the walkthrough together, and the landlord's like, "Oh, I'm busy," you can say, "No, the legal order that we signed says you need to do the walkthrough together." So now you're in violation of that legal order. So I like to have things clearly written out. And then, yeah, you said, what am I going to do with the security deposit? I'm just giving it up. Maybe this person owed rent. Um, So this is another one, and it says proceeding discontinued without prejudice. Without prejudice means they can bring it back to court. Petitioner reserves all monetary claims against respondent, including without latches, rent, added rent, use and occupancy, late fees, legal fees, um, something fee, security fee, and electricity fees. Okay, this second part I really don't like, because it means that when the person, I as the tenant, if I sign this, it means that I'm saying that we didn't deal with any other types of fees or rent that was owed in this apartment. This means I'm agreeing that we're not going to deal with this in this case, but then in the future, the landlord can sue me for this, and I'll have to deal with it at a future point, maybe. I prefer to just deal with this in this case and say, okay, you're going to waive the rent, or I'm going to pay this much, and then we're just going to let go of everything else. You don't want a situation where you have to deal with it later. I don't like this type of language. But yeah, they're reserving all the types of fees they can come after you for. And certain fees in housing court, you can't come after them for. So it's legal and late fees. You can't be evicted for legal and late fees in housing court. Now, once you're evicted, you need to get back in to the apartment, then you need to pay it, but you can't be evicted for that. So I really don't like that this was included. So these are just some examples. Now, some tips. When this stipulation, if you see, some of them are pre-printed out, some of them, they're handwritten. You don't have to use a pre-printed out form. A lot of times landlord or landlord's attorneys will bring in the form that their office uses, and that tends to have language on there that is not helpful to you as a tenant. Remember, we don't understand legal language, but they do, and that tends to have language that's, like the whole thing about the reserving late fees and things like that. You don't have to utilize the ones that their office uses. It is your legal right to say, I do not want to use the pre-printed forms. I want to use the blank court ones that the courts provide. That is a legal right. And then, a lot of people think the landlord's attorney has to write it. Nope, you can write it. You can push back, you can cross things out. Sometimes the court attorney will write it if you guys are arguing over who writes it, because that's the mediator. But yeah, you do not have to use the pre-printed out ones, and you can write it. Again, you need to make sure you understand everything that you are signing. Not understanding the legal language because you are not a lawyer is not really a defense. You are presumed to be understanding of everything that you're signing. Um, it's in very rare cases that a stipulation can be overturned. And you need to be, even with a lawyer, it can be hard, you know, so you need to make sure you're understanding everything you're signing. Again, the court attorney is not your attorney. They work for the judge and they have a different goal than you. If you have a question, like let's say we go back to this one and you say, and before you sign it, you don't understand what minimis means. You can ask the court attorney. The court attorney is an attorney. You can ask them, hey, what does this language mean? So you can ask them questions, but again, they're not there to help you. They're there to help the judge. Now, let's say you violate the agreement to move out, then there's something called, you get the eviction notice. And a lot of times, people get the petition and they think that's the eviction notice. No, this is what an eviction notice looks like. And it'll say city marshal. So it'll actually have the marshal's number and it'll say notice of eviction. And then if you see on the bottom, it says earliest eviction date and date of notice. Date of notice is the date they gave it to you, and earliest eviction date is the first day the marshal can come to lock the door. If you are denied, like, an opportunity, if you can't get more time to move out and you need to know when you're scheduled for eviction, you can call the marshal. This is the marshal's number. You can call them and ask them. Do it after lunch hour. Because they might not schedule in the morning, but they may schedule you and put you on the schedule in the afternoon. And you can ask them, hey, am I scheduled for eviction? They're nice. Most of them, they're not going to yell at you. Just need to know your index number. But this is what an eviction notice looks like. Now, if you get the eviction notice, you may need to go into court to file something called an order to show cause. That's to get more time to move or do something. And when you go to court to file an order show cause, this is an example of what an order show cause form looks like. There are different versions of it. So when you fill out the order to show cause, there's like pre-filled out statements, and on here you have to initial every line that applies to you. But then there you see where this person, they wrote in some stuff. You need to make sure you don't leave that area blank, because you need to explain to the judge why you're requesting for more time or what your defense is. So in this case, this person wrote, I need more time to finalize my new apartment arrangement. I have applied to many apartments, see attached proof, but when I bring up my newborn, they say no. I was able to get City FEP's voucher to move, and I've been finding listings that accept City FEP's. I need more time to secure a new apartment. So when you are doing an order to show cause, you have to give the judge a reason to want to give you an extension. So it's not, I just can't find an apartment. She's relating a reason. Hey, I got a City FEP's voucher, which for anybody who doesn't know is a type of voucher to help you pay for an apartment. And then she's also saying that this is the specific reason a landlord may not want to rent to me. And then she actually provided proof of this. So I didn't attach the proof. But it's good to attach proof, because remember, judges are hearing hundreds of these cases per week. They don't want to just hear about it, they want to see it. So when you go, you have to go in person to file the order to show cause. If you get this marshal's notice, do not wait until, like, this was March 12th. Do not wait until March 11th, because what if the judge says no? It's not a guarantee. You have to go in to the clerk, get this form, fill it out, bring a pen. The courts do not provide pens. Fill it out, give it back to the clerk, and then wait to see a judge the same day. That could be a very long, an all-day process. And then you get in front of the judge, and the judge takes a look at the paperwork and may say, nope, I don't agree with this reasoning. So you may need to refile it. Maybe the judge wants, if this person hadn't attached proof, maybe the judge wants more proof, you know? So make sure you give yourself enough time to come up with a plan, because if they deny it, maybe you need to refile with more evidence, or you maybe need to unfortunately create a plan to leave the apartment because you cannot get in more time. If the judge approves the order to show cause, you will get a follow-up court date. So this is just a preliminary approval because the landlord needs to be given an opportunity to say, no, I don't agree with this extension request, and this is why. So they schedule a follow-up court date where the landlord will be present. So it's not just you got approved, you need to come up for a future court date. It just temporarily puts the eviction on hold. But also make sure when you get it, and you'll be told this by the court attorney, who is usually the person who speaks to you when you fill out this form and the judge approves it. There's instructions here that you need to serve the marshal and the other side. Make sure you follow the instructions exactly how it's written on the where it says attorney or marshal, because if you do not, then, or if, like, let's say on this paperwork on the left hand side it says on or before February 21st, if you do it after that date, then your order show cause could be canceled essentially because you didn't follow the proper instructions. If you don't send it by certified mail or by first class mail, um like, because sometimes you go to the post office and the post office worker, and trying to be helpful, will say, would you like to send it for a cheaper option? No, you need to follow the instructions exactly how it's written on the order to show cause approval paperwork. And if you're confused, whoever gives you the notice, ask them, um, hey, I'm confused. How do I serve? Sometimes the writing is not great. We know how to read this. It says, or you could do any of these methods, but you may think I need to do all of them. Just ask them questions. Whoever gives it to you, ask them questions. Now, let's say you need to move. There are very limited agencies that can help you move. Let's say you have an apartment, but you need help with the security deposit or moving expenses. You can go to HRA. If you need help moving, you can apply to HRA. Also for public assistance payments for shelter and other costs. Basically, it's a very limited amount, around like $215 for most families per month. If you move into another apartment. FHEPS and City FEPS, they provide more assistance towards like paying for an apartment. You would go to your local home base. So home base is a city program, and it's contracted out to different agencies based on your zip code. So some people have Bronx Works home base, some people have Catholic Charities based on your zip code. And you can apply, you would make an appointment with them to see if you're eligible for the FHEPS and City FEPS. FHEPS is usually for people with children, and City FEPS is usually also for people with children, but also adults only. They have different criterias, like you may need to be in shelter, you need to have a court case going on. Not everybody's going to be eligible for it. It is income based. So it may be an option for, like, let's say your landlord wants you out and you need help looking for an apartment, but you can't afford one on your own. This may be an option. You just need to be screened, but the criteria are pretty strict and they change all the time. So go to your local home base, call them to be screened to see if that's an option for you. Unfortunately, if you're evicted and you have nowhere else to go, there is the New York City shelter system. You don't have to sleep on the street, depending on the type of family you are. So if it's, if whether it's like a husband and wife or a family with minor children, you can go to the family shelter, which has a different intake center than the single adult center. Yeah. So you can look at, this is the link, and you can go where to go, and they go and assess you to see if you're shelter eligible. Assessing means they can they basically want to see that you have absolutely nowhere else to go. Like you can't go stay with your mom or something like that. So that is the end of their training. So this is our contact information. So that's our number. Again, we're open Monday through Friday, 9 to 5. And then I'm gonna just basically go through the chat to see if there's any questions. Um, I do see, okay.
Hey, Nipa. So I don't see any questions, but mostly it's my comments on reinforcing what you were stating. Um, so now that the presentation is concluded, does anyone have any questions that they would like to address during this presentation? Thank you so much, Nipa. You gave us a lot of information, and this is firsthand information from you because you usually table at the courts, right?
Yeah, I'm sometimes in the Brooklyn courthouse. You can find me there on select days.
Right. So you deal with a lot of families that are already in housing court, seeking, information on what to do. So I actually have a few questions, and this is in regards to the illegal lockout.
Mhm.
Um, Now we all know, especially after this presentation, that as soon as you find that you are locked out of your apartment illegally, meaning it's still your apartment, and you call the police, and let's say the police let you in. Is there still any type of documentation that a tenant can request that's sufficient to prove that there was an illegal lockout, like a police report?
Um, so when you call the police, sorry, can you just repeat? I just want some clarity.
Yes, sure. Is there any type of sufficient documentation that a tenant can retrieve from the police confirming that an illegal lockout just took place?
So the thing is, like when you call the police, it's they should be able to help you with the illegal lockout itself. Um, so you just need to provide proof to them that you know, that you actually live there. So they can actually get you back in this apartment. They can order the landlord to open the door and let you back into your apartment. So they should be the one assisting with the illegal lockout. But if you call the police and they don't help you, they may say you need to deal with the housing court because of the fact that they may not be able to determine, or first maybe they're not well trained on this. Um, then at that point, I don't know if you get any sort of report, and I don't know if the report will actually help. Simply because, yeah, it may just say like we told them to go to housing court, things like that. So I don't think it will be helpful. If you can get it, I guess so. But I don't know if they're not helping you to get back in, like if they say that well, they won't open it because sometimes what happens is the landlord won't be present in a building. That may be helpful, but you really don't need it. The most important thing you need is that um you live there. And if sometimes like you're getting trouble from the police and they're saying we don't deal with this situation, their patrol guide, section 214-12, and I'll share my screen again. Um actually says that they're supposed to help you um with a illegal lockout. So this is their section of their own guidebook that says they're supposed to help with an illegal lockout. See how comfortable you feel pushing it. I don't want a situation where you push it and now they're going to arrest you. Unfortunately, those type of situations have happened. So read the room, you know, and see if you feel comfortable asking for a supervisor. Do so if you feel comfortable, you know, um, referencing this law or the patrol guide, then do so. But again, don't push it if it's going to result in you getting arrested, because that's going to create a bigger issue.
Thank you so much for that. Um, let's see. Give me one moment. Also, so we talked about types of accommodations that a respondent can provide if let's say the respondent being the tenant who is being taken to court, if they are unable to respond to the new court case to, basically provide an answer, let's say they're in the ER or they're in urgent care, what's the best thing to do? And what type of documentation can they provide? Obviously, some medical documentation.
Yeah, I mean, you don't necessarily, with the holdover case, you don't need to provide an answer because your answer generally will be given um on the day of the court date. If you want to, you can. But let's say you're in the ER, you should call the courts to let them know, hey, I'm currently in the ER. You can have the social worker call also sometimes. Um, it's different. Uh, it's pro se tenants or tenants who without lawyers, um, get a different response about, what is if the court case will go on or not. If you're in the ER and you're adult, you may need APS services at that point. So I would say potentially the social worker should reach out to APS depending on the situation. And if there's an APS investigation going on, the court should be notified of that there's an APS investigation going on. Because an eviction, it's not that you can't be in court, but the eviction can't take place until the APS investigation is complete.
Okay, thank you for that. We also have someone in the chat who has said that they received a stipulation to be out by the end of July after an adjournment to retrieve a lawyer.
Yeah, I would tell them like definitely call our phone number. Um, so maybe we can look over the case because like I don't want to give any advice, especially it's a personal case, but also I need to be able to see the full stipulation like we were talking about. You can't just take parts of a stipulation. You need to be able to read the whole thing to see in context like what exactly it means.
Yeah, understood. So definitely call Housing Court Answers hotline. If you are a person who has a member of the household that is OPWDD eligible, so that is the New York State Office of People with Developmental Disabilities, you can always contact Synergia to request an intake for case management services, but definitely call the hotline. Does anyone else have questions at this time?
I actually forgot to mention one thing because since we're providing translation also, if you are someone who needs a translator during the court process, you are entitled to a translator. So you need to call the court. You don't need to even go in person. You need to call the courts in advance, provide them the index number, or when you maybe go to the courthouse, let them know I need a translator. It's not up to the courts to determine whether your English is well enough for you to, go through the case. If you request a translator, that is an entitlement you should be given. And let's say you show up on the court date and the translator is not present, you should the case should be rescheduled or adjourned until the translator comes in. If they try to move forward through the case without the translator present, you can ask them to put that on the record because that could be potentially grounds for an appeal. They don't want that. So ask them to put it on the record that you've asked for a translator and it's you know like you're not being provided one, and that puts the courts on the defensive. But also you need to ask in advance, like they cannot, certain languages like Spanish is like a pretty easy language to get, but even though sometimes maybe there's not enough Spanish translators in the court present that day, but something like Bengali, a more uncommon language, they may need to hire the translator, order the translator to be there on that court date. So you need to let them know in advance as much as possible. If you do it one day before, you're most likely not going to get the translator that day.
I also wanted to go over, I know I told folks that I'd share a screen. So if I can do that, Nipa, I'm going to go ahead and share this document. It's just a slide, and it basically shows it basically shows what the 200% of the federal poverty level is. So I'm just trying to share that now for 2024. Let me just make sure I have that up. because the federal poverty guidelines are, you know, reviewed every year. So this is something that's important to tell. And I actually also put that document in the chat. Let me just make sure we have that particular slide. Well, just go ahead and include that in the post-webinar email, but essentially you want to look at your household size, right? Household composition. If it's a household of one person, this is the monthly income limit. You can make at or under for free legal representation, and then it annualizes the income as well. So that will be shared after the presentation in the post-webinar email.
And I just want to share my screen for a second. So I, I we have a lot of trainings that are available on our website, and I put it on the chat, but just in case some people are calling in, you can see if you go to our YouTube page and you hit live, you can see a bunch of trainings that we did. So the good cause eviction law that I was talking about has the more in-depth, so you can review it. We have a lot of times we have the lawyers doing the trainings, so they're providing legal advice potentially. We have the overview of order show causes, so we show you how to do different types of order to show causes. If you know a Bengali speaking clientele, we have this translated into Bengali. It's an overview of housing court. And then the NICEF one, if you want to learn how to search for cases on NICEF, we have a training about that. So um there's a bunch of training, and we always have like new trainings coming up, things like that. So you can always just register for our workshops. Right now we currently don't. We just finished training, the good cause eviction training. But if you go onto our website at housingcourtanswers.org and our workshops, you will able to see that you will be able to see if there's any upcoming workshops and register for them, but also past workshops, and then just information. Yeah, like if you want to learn about holdover, like you're confused, you can just type it in. What is a holdover case? So things like that. So just feel free to like play around on the website.
And also a final reminder that we have a presentation next Wednesday, another webinar with Housing Court Answer staff, and this is going to be on non-payments. So I just put the link in the chat. I see that we don't have any other questions. Nipa, it's been great. You gave really good examples of stipulations. That's something that's super important, especially, having seen a lot of families be in housing court and you're looking at all these, harsh languages, you don't know what the repercussions are. So thank you so much for highlighting all of that for us today.
Of course, not a problem. Thank you again, everyone. And yeah, the person in the chat, just our phone number, our phone line is, open right now. So 212-962-4795. We're here till 5 p.m. today. So if you have a question, you want to discuss something case specific, and even if you're not in court, or you're just backed up in rent, or you have like repair issues, just feel free to call us.
Thank you guys. All right. Have a good
Of
one.
course. You too. Have a good day, everyone.